The U.S. Supreme Court is scheduled to hear opening arguments in a West Virginia case that USA Today described as having the feel of a best-selling novel. It involves whether State Supreme Court Justice Brent Benjamin should have stepped down from a case involving Massey Energy because CEO Don Blankenship spent more than $3 million to help Benjamin get elected. The case is called Caperton v. Massey, and the plaintiff, Hugh Caperton, sued Massey, claiming the company forced his smaller company into bankruptcy through fraud. A Boone County jury found in favor of Caperton and awarded him $50 million. Massey appealed the verdict to the state Supreme Court. Caperton's attorneys asked Benjamin to recuse himself from the Massey appeal, but Benjamin refused. Now the U.S. Supreme Court has agreed to rule on whether it was ethical for Benjamin to participate in that 3-2 decision in favor of Massey. Cecelia Mason spoke with Caperton about what he hopes to get out of the appeal for himself and his bankrupt company, Harmon Mining.
Harmon Mining is defunct and will never be able to go back into operations again. The claims from our creditors in bankruptcy court are over $30 million, with the large part of that by far being our future medical benefits that are owed to the union miners. And so that's what we're fighting for. We're fighting to have those medical benefits paid. We're fighting for the small business owners and vendors that we bought equipment from and supplies from when we were operating Harmon. These are the people that have been hurt, and this is what we're trying to get this thing reversed and get the original jury verdict reinstated so that we can pay these people the money they have due and owing them.
Why did you decide to pursue this?
We think, obviously, that Justice Benjamin, who cast the deciding vote twice in our case, was the benefactor of a $3 million spending spree by Don Blankenship to get him elected in 2004. And we believe that creates, certainly at the least, an appearance of bias. Certainly we were denied our due process and rights to a fair and impartial trial.
What will you do if the U.S. Supreme Court agrees with what you're saying?
Well, I would assume that what we would do is we would go back to West Virginia, to the Supreme Court in West Virginia for further hearings with Justice Benjamin being recused. You know, when you look at the makeup of the court and what it was when we originally went in front of the court in October of 2007, as an individual, I went into the Supreme Court that day and I looked up at a court made up of 5 justices, one of which had been vacationing with the CEO of Massey, Don Blankenship, on the Riviera, and one of which had received $3 million indirectly from Don Blankenship in his bid to be elected to the Supreme Court. And it's very difficult as an individual like myself to look up at that court and see the fairness in the makeup of that court. We certainly welcome the changes that have been made to the Supreme Court, and we look forward to the day we can come back and have our case heard in front of what we would perceive to be a fair and impartial justice system.
Were you aware at that point of the Riviera vacation?
Oh, no, absolutely not. We weren't. We were certainly aware of a friendship between Mr. Blankenship and Justice Maynard.
What do you do if the U.S. Supreme Court doesn't agree with you?
We don't want to look at that possibility right now. We're confident that the U.S. Supreme Court will rule in our favor. The issue in front of the Supreme Court is an issue that really affects every citizen in this country because it's every citizen's right, it's their fundamental right to a fair trial in front of fair and impartial judges.
What's it been like battling a big coal company like Massey?
It's been the hardest task of my life. It's very difficult. Massey is a very litigious coal company. They litigate everything. It's been a tremendous undertaking. It's been devastating to me and my family, and it's been devastating to all the miners that lost their jobs at Harmon. But it's a battle that's worth fighting. We know we're right, and we're confident that the U.S. Supreme Court is going to prove that.
West Virginia Supreme Court justices don't comment on ongoing cases, and Justice Benjamin has not granted interviews concerning this issue. In his opinion on the Caperton case, Benjamin wrote that the mere fact that an independent political group waged a campaign against his opponent is not enough to disqualify him from hearing the case. Massey Energy did not respond to a request for comment on this story.